the investigation officer reasonably believes that the stolen property is concealed, all right, then he'll go and ask for the, he go inside without warrant. All this must be recorded by the IO. All right, okay, right. Search without warrant under section, need search without warrant under CPC section 62 and search without warrant under section 1161. So there are two sections. If IO consider document or other materials necessary for the investigation in order to reproduce such document or things will not be obeyed, he can search the premises without warrant. What's the difference between this section and the other one? The other one is because he believes the stolen property is there. Right? Tapi, and the second one is because it is related to document. So be very careful, right? In your report, there are two sections to go inside and have the raid done without warrant. All right? If you are looking for document or material necessary, pen drive, for example, camera, for example, all right, then you look under the action under section 116. If you already know the stolen property, the bicycles or the whole bunch of money stolen from the bank is there or taken out from the bank is in that house, then you go under the other section, all right? Seize of the property, all right, seize of the property, okay. All right, then you, okay, that one is a repeating section, isn't it? All right, so dia dua kali saya letak kat sini, property is alleged to be stolen or property is suspected of being stolen. All right, if found under circumstances which create suspicion that a crime has been committed. Yang ini apa? Kerana in court you have to prove the case beyond doubt. Prosecutor likes that. All right, that because that thing is inside the house, inside your bag, therefore you are the one who took the stolen property. In possession of, sometimes the word is, right? So, right, jadi if the goods is with you, definitely the scenario is that, the conclusion is that you are the guilty party. It's up to the defense people to say, you don't even know, you share the room with 20 other people, then there is a defense for you. Otherwise, you are going to be the main suspect here because the stolen property is in your room, in your location, or in your possession. All right, interrogation. That's the other one. Interrogation. So I'll jawab. All right, or in the ordinary understanding, the police called you for interview. All right. Okay, IO can interrogate the witness and also the suspect. All right, they can record this one, interrogate. What's the difference between interview and interrogate? Right, interrogate, usually they ask you the same questions over and over by 3 or 4 investigator or investigating officers. Right, they come in and they say, Puan Rohani, ingat tak apa you buat pada 27 hari bulan Jun, 27 hari bulan April hari tu. Alright, and then the other people will then I say, oh saya ingat, that is the day that that man gave me the money. All right, and the same one they will ask you. That's why it takes you 7 days. All right, and they should be able to, all right, decide what would be whether you are lying or not. That's the problem. That's the point, the objective of interrogation. All right, in the interview, they ask you the question over and over, and then they twist the questions like this. All right, did you get the goods on that berapa 27 hari bulan April? All right, were you alone? Is there anybody? And then they turn around and say, who was with you on that particular day when you received the good? Do you remember the date? Is the date correct? Can you see? Over and over in a different mode of. All right, there is a tactic. There is a technique, interrogation, to get the person to say and to get to know that the person is not lying. Sometimes you forget. Even when you forget, if you are being questioned or interviewed or interrogate, you simply just say, I forgot. I don't know about that. don't lie, because you get caught in the interrogation. Yeah, all right, everything will be recorded. Now, after the interrogation has done, all right, okay, or sometimes when it is not done, because when they asked you, you didn't come, right, you can then be arrested. Arrest, who can arrest you? All right, I'll go a little bit further kat sini by telling you that police officer, pengulu, private citizen, and magistrate, these are the people who can arrest. Police arrest is under this section. All right, police can make an arrest. The offense is seizable, may arrest without warrant. Tak kisah. All right, tadi we talk about it. They have reasonable suspicion of such offense being committed. Under suspicion, reasonable suspicion and suspicion is two different things. All right, usually, all right, reasonable suspicion is put on the head of the team of investigation. All right, they have received credible information about, all right, the arrested person. Credible information. All right, they, you know, you show the picture in the TV and suddenly, all right, someone show snap a photo and send it to the police. The police have all right, rights to use that information to go and arrest the person. The person arrested has been concerned with such crime, or you know, there are 4 people who are committing theft. All right, through the investigation, one of these people will then sneak the name of the other who got away. All right, from that way, it's also related to. So out of this, police can arrest. This arrest is what? Is in line with the investigation. All right. Okay. Now the next one, the more interesting, is citizen arrest. Who is citizen? Anyone in the public can commit arrest. But for the arrest citizen to commit an offense, the crime was committed in his view. You nampak makcik tu punya beg kena ragut. Alright, okay. You nampak this man is being, this man take the money from someone else's bag, for example, or from the bank, or you, alright, okay. So the point is, the crime must happen in front of his view. Then he can go and arrest. How would you arrest? In one of the funny situation case when I was learning criminal procedure, is this lady, she was all dressed up to go for dinner at 6 o'clock. You know, suddenly she saw someone steal money from the ATM. All right, she go there, she banged that man with the handbag. All right, and then she clobber the man with the high heels and then sit on the man back. All right, okay. And she is a very fat lady, and she called for the police. The police come in, the man need to be taken to the hospital before he can be taken to the, because the lady was really very heavy. Still, that is citizen arrest allowed. She's not guilty in, all right, hurting that guy, because she saw the crime in front of her eyes. The same thing. Selalu bila you nampak people are being snatched, snatch theft, sometimes you want to go and catch that guy, and then you can arrest, and then you can bring him to the police or call the police later. All right, but the clue is that it must be happening in front of your eyes. Now, during the arrest, all right, during the arrest, the suspected person may require the assistance of a lawyer. All right, during the arrest, all his statement will be recorded. All right, okay, any question or recording that made that way, all right, okay, shall be deferred. If he is, all right, going to call for the consultation of a lawyer, meaning lawyer will come. Right, so you tak boleh nak go through with the recorded statement. So the faster you call for a lawyer, the better. But usually for you to call a lawyer in Malaysia, calling a lawyer is a difficulty. All right, we always worry that we have to pay the lawyer. And if you are a criminals, you cannot use the free lawyer service under the Biro Bantuan Guaman. Tapi, right, one day I'm sharing this information with you. Manalah tahu any one of you will be able to change the system. All right, in Brazil, I've been to Brazil. I've stayed with the Duta over there, learned a few things about Brazil. Accordingly, the best place for lawyers to be is in Brazil. Although Brazil is not one of the rich country, but Brazil is a duplicate city of Europe. Yeah, a lot of European are in Brazil. In Brazil, if you got a job, all right, if you got a job, doesn't matter what job it is, you will hire a lawyer automatically. All right, the fee is really very small to the amount of your salary. You will pay monthly percentage of your salary, maybe 35 ringgit, like you are paying insurance, all right, per month to this lawyer. All right, the lawyer will make sure, because you got a job, that you are protected by the law. And in your job, all right, okay, they cannot make you work overtime. They must pay you if they work overtime, and nobody is going to cut your salary or reduce it without authorization. Sometimes the majikan, the employer want to add bonus, that would be good, but cut allowances, that will be bad. So the lawyer will go and meet the employer, all right, and ask for demand of reason, or demand that the employee have no reason to do the extra deduction. All right, isn't that good? Now, because you have a lawyer that you pay monthly, all right, fees, this lawyer will quickly defend you if you get caught. All right, or if the police arrest you for a wrong reason, or even for the right reason, so the lawyer will come. And of course, because the lawyer are doing that, then the premium will be higher the next time. All right, tapi at the end of the day, you got a lawyer. You know already the name of your lawyer. It's not something that you have to cari. You have to go and hunt for one. Isn't that beautiful system? All right. All right. Okay, this one trigger because we wanted to go visit the other side of Malaysia, Malaysian in Brazil, and it was already past 6 o'clock. We want to call our driver, but the Duta mentioned that we can't call the driver because the driver will not work unless there is an agreement for him to be signed earlier. In the earlier agreement, there was no extra works after 5:30. All right, macam tu. Because the lawyer will come. So if I want him to work after the 6 o'clock, all right, I will have to call him. He will make sure that the lawyer knows about it. And next time, then when he comes, all right, either I must sign a little piece of paper to say that he will be paid for his extra work by the end of the month. All right, so the best place to be. But anyway, Brazil is beautiful sky, all right, because they don't use petrol, they use tule, if I'm not mistaken, the gas from sugar cane, all right. Okay, so the air is clear because it's a natural energy. And the only thing is the section that are rich is only in the section of Brasilia. All right, in the rest of the Brazil, Sao Paulo, whatever it is the substandard kind of living. All right, okay, there are no train running into the main city, all right, but there are train are only running at the outskirts of the city Brasilia. Right, okay, but anyway, having said all that, that is a situation that I've learned. Maybe one day when you are the prime minister, you would want to give a lawyer a job like this. All right, isn't it wonderful? So the lawyer will not be looking for nowadays is a difficult time, all right, to get a job in the law firm. All right, okay, being a law student, but jobs are coming back, isn't it? All right, at this stage, a lawyer can be appointed by the suspect person to oppose the remand application. All right, so nobody can remand you, all right, if there is no reason for, there is no reason to prove that you are a good suspect to stay for the remand order of 7 days or 14 days. Appointment of a lawyer shall be made promptly and possibly the minute the suspect person arrested and brought to the police station. That is a caution statement. One of my students in my previous class, forensic accounting, he was charged with by the SPRM. At that particular time, SPRM was like charging almost everybody that have money more than 1 million, all right, for corruption. Okay, so he was one caught, taken to the police and then charged. All right, okay, but he did the inquisition. He did the inquiries and interview for the first 24 hours and hold for another 7 days. All right, okay, but he didn't know that he can call a lawyer anytime then. All right, so now that you know, okay, all right, you must call for a lawyer, and somehow it's good to have to befriend a lawyer. All right, okay, now let's look into detention period allowed. Police have a rather short time following an arrest during which they must either charge or released. 24 hours or under section 28, as I said, no need to put the section 24 hours, all right, or released, or go for magistrate, ask for the magistrate for the extension. During the extension, if you are kept in the proceeding, it is called remand proceeding. This is in the new division of criminal litigation process. It is the second stage. All right, in the second stage, all right, you are going to be remanded there maximum 7 days or maximum 14 days. All right, okay, now application, who will make the application? The IO will make the application to the magistrate. If the IO completed, all right, and then the IO will then, all right, okay, try to get as much as possible from the interview and recorded it, or try to locate the evidence. All right, okay, now then the IO must show the period of that 7 days of remand or 14 days of remand in his diary. All right, okay. At the end of that, when the person is released from 7 days, they must show to the court that they have information needed from in the diary. All right. After that, okay, he will be released, isn't it? Right? If remand is paid, all right, and the bail are given, he will be released. All right. Okay. Now this is the stage 3. Planting for the charge and bail. Soon after the period of remand has expired, the criminal charge will be read if he is guilty. All right, okay, and explain to the accused. What is explained to the accused? All right, sometimes the accused cannot speak the language, so you got to have an interpreter to explain to him the charges and why he is now not released but kept. All right, if the accused does not understand the nature, the accused person is entitled to enter. All right, if the accused understand the nature of the crime, right, that you have committed theft, you have committed CBT, you have committed criminal misappropriate, then he will have to enter a plea. Right, nak kata dia bersalah atau tidak. This is the pre-trial. All right, okay. Now lepas tu, you have the right to be represented. The person who is charged now is no more a suspect, he is an accused. Okay, again, maybe you want to call for a lawyer, right? If the person plead not guilty to the charge, the lawyer will request for bail application. Kalau dia dah charge, bail application. Some are bailable offense, some offense are not bailable offense. But bail application is when the court will hear submission from the accused lawyer. Tadi call for the all right, remand is the IO, call for the bail is the accused lawyer. All right, if the court grant bail, the accused will be released from custody. But the criminal case is not over yet. Dia cuma boleh balik saja, tapi the case is not the case is not coming to an end. Dia belum lepas lagi. Only because bail. What is bail? Bail are money fixed by, all right, the accused in order to secure that this fellow will come back for the trial. That because he is only committing corruption. If he cannot meet the amount of bail fixed by the court, then he will stay in jail, all right, during that period. Tapi selalunya orang when you are involved with corruption, you'll be able to. And if you can't meet the amount, let's say the amount is 4 million that is demanded on you, like in the newspaper said before, then the lawyer will ask for a reduction of that to the more reasonable amount. Maybe 1 million will be good. So in the case of Najib, our former prime minister, all right, he was supposed to put on bail for 4 million, but he cannot have 4 million because all his assets has been freezed. So he has to request some money from all his families in order for him not to stay in jail and to get to go home and wait for the date of the trial. All right, so they then, all right, allow him to reduce from 4 million to just 1 million. So the child come into the picture. I think one of the kids come into the picture and pays that bail money, and he and his wife are home. All right, waiting for their turn to go to court. And they have been coming to court quite often whenever it is necessary when the trial is on. All right, that is how it is. The accused shall compulsory, all right, attend every hearing fixed on the time. Dia tak boleh kata sakit ke, boleh kata sakit, but they have to inform the judge, the lawyer, all right, that they are not coming. Either sakit gigi ke, sakit perut ke, all right. Okay, that one is allowed. Again, if you're repeating that sakit too much and delay the proceeding, and if it's one of the excuse were not really true, you can be contempt of court and you go to jail for no reason. All right, contempt of court sebab berbohong dengan mahkamah. Decision to prosecute. Right, once you are already there, the bail, and you are out going home or you are stayed in there, all right, now it's time for you to be prosecuted. Decision. The decision is with the AG. Right, the charge. Decision to write down the charge. All right, charges. Notice to the accused of the matter is that he is committing the offense. Notice, charge is a notice to the accused of the matter he is accused of committing. All right, that is what a charge is all about. Right, accused will be charged in open court. Dia tak boleh baca dekat dalam court. Dia tak boleh baca dekat dalam bilik. All right, it must be in an open court in a preliminary hearing. Preliminary hearing is the initial hearing. Baru pergi saja untuk baca charge saja. Anda di-charge dengan tuduhan corruption ataupun CBT under penal code. Right, for example, the charge will be read and the defendant is asked. Lepas tu he will be asked, all right, guilty or not guilty. Most of the time, people would say not guilty, although the advice is always to say that you plead guilty. If you plead guilty, sentencing will be shorter. This is what they promise. But my advice, lawyer advice, never plead guilty on something you are not guilty at. All right, so if you're not guilty, you plead not guilty. All right, you are the only one who knows. The lawyer will not be able to coach you here. But some lawyer sometimes also advise their client faster the trial, isn't it? All right, tapi that is a bad advice. Yeah. All right. In serious cases, no plea is taken at the time the case will be tried in the High Court. Itu kalau dekat High Court. Defendant lawyers of corrupt appointee. Defendant lawyers of or court appointee. Right. Itu kalau murder cases. That it will be a different one. We're not talking about these murder cases. Yeah. All right. Okay. Now charge. The general principle, charge must be precise and not vague. This semester question is going to engulf into all those process because you jawab satu soalan aja. Alright, semua sekali daripada mula sampailah habis pergi court and trial and punished. Alright, okay. So general principle, charge must be precise and not vague. A charge must be complete. All right, charge must not be wrongly framed. All right, so dalam charge tu to say that these are the general principle content of the charge against the accused. All right, and what must be there? What must be inside it to be in the position precise and not vague, complete, and not wrongly framed. All right, number one, they will talk about the time. Rohani Muhammad Shah, Rohani, nama saya panjang berjela. All right, okay. Let's say Rohani Muhammad Shah, you are charged with the offense of criminal breach of trust on the 10th of August 2019, committed in the location of your office, all right, Harta Emas Office, Jalan 2. All right, the person against whom or things in respect of which the offense was committed. All right, you committed CBT, all right, against your own office. All right, okay, the Lina Rohani firm, for example, in Harta Emas, all right, the exact language of the law, you dituduh, all right, perkataannya, okay, the section of the law under section apa? CBT 420, 420 berapa, all right, and therefore, if found guilty, you will be punished with section 214, 215, 420, 415, for example. All right, let's say if I am charged with theft, we all know theft 378, the punishment is in 379. All right, nampak tak tu? The particular must be clear. Siapa orang tu? The person is Rohani binti Muhammad Shah. All right, and sometimes in Malaysia they even go further, but that one is not required. All right, okay, but in the borang it must be stated the IC, tapi in the charge itself just the name, the time, the place, committed the theft against siapa? A theft against Rohana Muhammad Shah, for example, where? In the building of Seri Alam, for example, you know. All right, so these are the details that must be there, and that detail is requested in the CPC itself, 152 and 153, right, to meet the general principles of writing charge. It cannot be, all right, charge must not be wrongly framed. Dekat sini nama orang, saya Rohani binti Muhammad Shah, all right, okay, for example, some people are Rohani binti Shah, some people are Rohani binti Muhammad. You cannot be incomplete. It has to be complete. All right. Some people name has a hyphen, some has apostrophe, some has comma, some has a double dot. All right. Okay. All that must be taken into consideration, because those are the nitty-gritty that going to delay. It's not going to be you are going to be released because the charge were wrongly put, but if the charge is wrongly put, not clear, not precise, all right, okay, the lawyer will always then ask for the trial to be postponed, or to stay the proceeding, berhentikan proceeding too, or since you are charging a wrong person, all right, maybe this is not the charge, then he will be released, not that he will not be charged again. All right, okay, can you see? Wrong in the charge, it can still be corrected. All right, exception to the general rules. This is where you need to know. In the case of CBT and CMA, there is no need to state the exact sum. Tak payah. Jadi apa yang perlu kata, you mencuri pada nilai apa tu, alright, cheating to the amount of 2 million, for example. Alright, okay, but actually you were stealing 2.5177 million. All right, remember the case of Eric Chia. All right, the amount of stated in the chart are not the exact amount, but the amount is amounting to 2 billion, 2 million. All right, for example. All right. Okay, for CBT and CMA, the charge must be done within the same year of the crimes happening. Jadi, if you are an investigating officer and you know this is a case involving CBT and CMA, you cannot then run the investigation too long. You must quickly charge within not exceeding 1 year from the time the investigation start. All right. In the CBT and CMA as well, you must remember no need for exact date. You tak tahu bila, you know at the time when he was appointed as the president of Pewaja, he have committed. When exactly did he committed the act? We don't know, but we know only after when he wanted to, when the audit do the balance of the account. All right, the date are not to be specified, but it must be within 1 year of the crime happening. All right, okay, boleh? Right, any question here? Anyone?
No, Prof.
Okay, all right, bagus. Kalau no, all right, then, okay, right, kita continue with the bail. All right, bail again, all right, it is process of temporary release. Ni tadi kita dah cakap bail, all right, tertunduk kat bawah. Zulkifli case, bail of 1 million for CBT offence was reduced to 200,000. It was held to be too expensive for him. He can't afford to pay. So bail in the situation of CBT doesn't have to, as long as ada jumlah. Sebab tu then we understand why in the case of Datuk Najib, the bail dia tu is allowed to be reduced, because there have been cases before that the court allowed the bail to be reduced from the amount they asked to the amount that is smaller, that the person who now under custody, all right, is able to pay, or the family of that person able to pay. Who can grant bail? All right, these are, all right, who can grant bail? The police, the magistrate, session court, high court. When can accused apply for bail? Bila pending trial or pending appeal. Category of bail, to the bailable offence or non-bailable offence, or in a situation that is bail is not allowed. In a case situation of murder, bail is not allowed. Tapi dalam case the murder of the CIMB CEO of CIMB hari tu, alright, the lady was allowed bail, even though she was a suspect in murder together with the kids, right? Okay, now it's not that the court are making precedent that it has never done before, but the court are doing it because there have been situation that the court follows itself that it can allow bail on a murder charge. Alright, okay, sebab apa? Hari Raya. Alright, bailable offence. Alright, there are two types of bail. Ada yang bailable offence, ada yang tak bailable offence. Alright, okay, it's up to, if it's non-bailable, it's up to the discretion of the police. Alright, bail is not your right. Okay, bail is of right, not a privilege. Any punishable offence with 3 years or below, you can allow bail. Alright, any okay, anything that is other than that, it's up to the police discussion. Okay, right. Okay, sometimes court tak nak grant the bail, can tak nak, alright, not the court discretion. Sometimes you request for, court pun ada discretion to grant bail. Court can grant bail if that is a woman requesting for a bail, a person under 16 years, a sickly person or infirm, infant, yang ni bukan infirm, infant, alright, okay, budak bawah umur 16 tahun, alright, okay, that is betulkan dekat situ. Alright, unbailable offence. Apa yang tak boleh bailable offence? Murder, case Dada, for example. Alright, okay, alright. Other than that, factor to consider in granting bail. In the case of Wee Sui Siang, alright, okay, the reasonable ground for belief that the defendant is guilty of crime, the nature and gravity of the offense, severity of the degree, danger of the defendant absconding, leaving the country, the defendant character, means and social standing. Apa ni semua? These are the ground that taken into consideration. Bila a person asks for bail for non-bailable offense. Ni semua area dia. Okay, so we Swiss Siang is really very important for you to support you to allow the person to go out on bail. Alright. Okay, factor to consider lagi, danger of the crime being continued or repeat. Kalau you were released, what is the danger? Danger of the witness being tampered. Alright, he probably will be killed. Alright, opportunity for the defendant to prepare the defenses. By now, they will destroy any evidence against him that might be found. Alright, length of the detention awaiting trials. Alright, dia akan lambat lah sebab you dah keluar, nanti nak masuk balik, you know, and start. Alright, so the length of the trial will be expanded because bail is granted. Yeah. All right. Charge read. Soon after the period of remand, the criminal charge will be read. Ni tadi. Okay. Bail will be given. Bail application after bail period elapsed. After bail made. Right. Once bail have already been made, the court can grant the bail. The accused shall compulsorily attend. Sorry, that one too. Dia terdouble dekat situ. You can clear off that slide. All right. Plea bargain. Not officially sanctioned in Malaysia, but plea bargain now is definitely allowed under the amendment. All right. Okay, you can plea bargain very quickly. What is plea bargain? All right, this is a situation. All right, defense lawyer or prosecutor will normally negotiate if plea bargain is possible. Dalam plea bargain, both parties, the lawyer and the PP, all right, must talk about pleading. Either they plead for the charge or they plead for the sentence. Charge meaning that he is charged with 48 count of corruption. Jadi kalau dia plea bargain, daripada 48 tu dia charge only 20 count of because sama 20 count of corruption. Alright, or they plead on the plea bargain on the sentence. The sentence is 30 years jail, but if he helps giving information on other people who committed corruption or committed CBT in the company, then because you do some that good, all right, the charge period too, or because you participate in giving all the information or prosecuting, all right, during the prosecution, all right, in this way, dia boleh apa? Boleh reduce the sentence. All right, we are going to break for a minute. All right, I notice there's a bell. Okay.